outside the record. With reference to various jurors having discussed witnesses and their testimony, what's set forth in the defense affidavits, even without contradiction, is so vague and meaningless as to have no significance in the context of a motion for new trial. I would note the enumerated instances of alleged misconduct in this area. The question by one juror of another, "What do you think of him?" referring to a witness. Or that another witness, Mr. Camden, quote, "was often discussed." Third, the likelihood of Mary Leone being unaware of the type of surgery she had had, quote, "was often discussed." And fourth, throughout the trial, after witnesses would testify, their testimony would be discussed by jurors. This is vague. It doesn't indicate any judgments on the testimony in question, any discussions of the defendant's guilt. Merely indicates that somebody appeared. For all we know, it could have been a discussion as to what the particular witnesses looked like physically, what their attire was. Certainly doesn't indicate any improper discussion, and I have to assume under 1122 of the Penal Code that that admonition certainly precluded a discussion after each witness of what bearing that witness had on the issue of guilt. On the issue of any possible discussion as to Mr. Buono not testifying, again, here the defense is rather vague in most respects. The affidavit indicates one subject of frequent interest was whether or not Mr. Buono would testify. Well, nothing improper with that. Also an indication that one of the defense affiants indicated that she observed Mr. Buono on television at home, which of course reflects an impropriety on her part, and that she felt he would testify. Again, one other juror asking whether or not Mr. Buono would testify. Another juror wondering why they didn't let him testify. Again, this is not these statements from a defense affiance. This does not indicate any improper significance being given to whether or not Mr. Buono testified. In fact, when these statements were made, I believe in all instances it was not yet apparent whether Mr. Buono had in fact testified, possibly with an exception for the last one. Now, the one statement that is made by a juror as opposed to an alternate juror is a statement of the juror who states that during deliberations there was a discussion during which several jurors argued that if Mr. Buono were not guilty, he would have testified. The one juror testifies to this. 3 jurors deny it in their affidavits filed by the people. And with the weight of the evidence, I'm able to find, again, beyond a reasonable doubt, that this never took place and that there was no discussion or argument that if Mr. Buono were not guilty, he would have testified. With this exception, everything hinges upon 3 alternate jurors tendered as affiance by the defense, each of whom has a demonstrated bias as reflected in the affidavits filed by the people. So I disbelieve the 3 defense affiants. I would also note parenthetically that the defense had raised the question itself during voir dire as to whether or not Mr. Buono would or would not testify. The court gave the appropriate instructions, Calgic 2.60 and 2.61, indicating the fact that the jurors could not properly consider that, and I assume those instructions were followed by the jurors. With reference to, I believe, a final point made in these affidavits filed by the defense, there was some indication that it was extremely common for jurors to read the newspaper and receive other media reports about the trial. No specification as to what was involved except for one mention of Mr. Camden's situation involving a motion for mistrial, which was denied. Again, this is too general. There's no indication of anything that would constitute the grounds for the granting of a motion for mistrial. And in fact, with the exception of the Camden mistrial motion, basically everything that I saw in the media was, despite some minor inaccuracies, a report of something that took place in open court that was not something from which the jurors were shielded. It was a discussion of what took place in the courtroom in the view of the jurors. And I think it is put very well by the Attorney General's office, and I think it's worth quoting a portion of their conclusion in the papers which they have filed in their opposition to the motion for new trial, and that will conclude my findings on the motion for new trial. Quoting from pages 12 and 13 of the People's Authorities, when one assesses the totality of this trial, massively extending over more than 2 years and subjected to extensive news media coverage, it is most difficult in reality to conceive of a jury less free from extraneous influences and possible bias than was this jury. Common sense tells us that it is not consistent with reasonable human nature to expect jurors to remain totally free from expression or emotions and to be isolated in thought and conduct both from outsiders and from each other. They are not and should not be considered robots devoid of human reaction or human computers relegated to absolute silence and impassive to the twists and turns of evidence, which was sometimes boring, sometimes bizarre, which was rarely humorous, and which must at times have seemed interminable. To expect that no comments would be made by jurors to each other under these circumstances is to expect that which is humanly impossible. The overall play of this ponderous trial makes the allegations of defense counsel pale with triviality. Defendant could not have had a fairer trial. In the context of 3 months of jury selection, 18 months of evidence, 1 witness alone on the stand for 6 months, 2 months of arguments to the jury, and a month of deliberations, the conduct of these jurors has to be considered exceptional and impeccable. The isolated remarks allegedly made and seized upon by the defense do not translate into biased, premature discussions of the evidence, prejudgment of the case, or prejudice to Angelo Buono, Jr. Now, I have found that no misconduct did occur or any improper receipt of evidence. That likewise has not occurred. But I will indicate that even had any or all of the alleged misconduct or improper receipt of evidence occurred, the court finds beyond a reasonable doubt that such would have been non-prejudicial in the context of, first, the very nature of the remarks or incidents themselves as alleged. Secondly, the strength and amount of evidence, the number of witnesses, the length of the proceedings. And in evaluating the evidence, I have reference not only to what appears on the 4 corners of the transcript, but my reference is also to the demeanor of the witnesses I observed, to the exhibits, including video and tape recordings, and to the jury views. Also, thirdly, in the context of the jurors' demonstrated fairness in returning a verdict of not guilty on count 12, which I consider to have been the weakest count. The fact also demonstrated that one of the jurors who was the source of what the defense seems to consider the most serious incident was a holdout for not guilty on the last count until she changed her mind. In conclusion, I find that the jury was discriminating and not discriminatory, and I note the length of time that the jury deliberated and the number of days between several of the verdicts and the length of time before the jury returned its first verdict. The motion for new trial is hereby denied in all respects. We will proceed now as to the next matter, which is a motion which was filed today by Mr. Filibosian as District Attorney of Los Angeles County, a motion to dismiss counts 1 through 11 of the information as originally numbered.
Thank you, Your Honor. May it please the Court.
Let me inquire before you proceed. There has been filed also today the following document by Mr. Wilbur Littlefield, Public Defender of Los Angeles County, who is present. That document being entitled, Objecting to Standing of Robert H. Filibosian, Current District Attorney of Los Angeles County. I gather, just to clarify matters, Mr. Littlefield, that the subject of this written objection would be only the actions that Mr. Filibosian desires to take vis-a-vis Mr. Bianchi's place of incarceration, and do not go to his standing to proceed as to the severed counts. Is that correct? All right. With that, you may proceed, Mr. Filibosian.
Thank you, Your Honor. We have filed a motion to dismiss counts 1 through 11, that is the non-homicide counts, and I will not go through a recitation of each one of those, since the Court and counsel have the people's moving papers. These counts were counts which remained in abeyance pending the trial of the homicide counts by the Attorney General's office. We have now viewed the remaining non-homicide counts with regard to what disposition is appropriate of those particular counts. An analysis of the possible penalty which could be meted out, even assuming that the defendant were convicted on every single one of those counts, would indicate that under the determinate sentencing law, under the applicable penal code provisions, and under the case law, that even if the defendant were to have been found guilty, or in fact were to have pled guilty to all of those counts, he could not be actually subjected to any additional time in custody, even presuming that he was sentenced to the maximum permissible under the determinate sentencing law. Because the defendant could not be sentenced to a single additional day in custody as a result of the time that he has already been in custody, the time he has already served, while the homicide counts have been in trial. The people have talked with all of the investigating agencies involved. District Attorney's Office staff members have talked with each one of the lead investigators, and in fact with the victims. All of those persons have been contacted, and all concur in the motion by the District Attorney's Office to move to dismiss counts 1 through 11, the remaining non-homicide counts. We are basing that on my recitation that the defendant, Buono, could not serve additional time in custody. We wish to save the victims of those crimes the additional trauma and inconvenience to which they would be subjected should there be another trial. We are also cognizant of the fact that an additional trial in this matter would be an extremely lengthy and costly process for the people of this county to simply litigate charges in a situation in which no benefit could possibly ensue to justice because of the length of time already served by the defendant. It is for all of those reasons, and for the reasons stated in our moving papers, Your Honor, that the District Attorney's Office at this time, representing the people in counts 1 through 11, the non-homicide charges, move to dismiss those counts pursuant to Penal Code Section 1385.
This is one prosecutorial motion to dismiss, which, unlike the earlier one made in this case relative to the murder counts, I have no reluctance to grant. I would inquire, although I assume you do not, whether there's anything you wish to state with reference to this motion. Mr. Chaler or Mrs. Mader. All right. The motion to dismiss the counts in question, counts 1 through 11 of the information as originally numbered, is granted as in the interest of justice under 1385 of the Penal Code, and the defendant is discharged on those counts. The next matter that we have is the motion of the District Attorney filed on December 27th, 1983, which I likewise have read and considered, a motion to vacate the order preventing the removal of Kenneth Bianchi from the Los Angeles County Jail. This amounts basically to a request that Mr. Bianchi be found in violation of his case settlement agreement, and that pursuant to that agreement he be remanded to the penal authorities in the state of Washington to serve his time. Now, as I've already noted, there has been filed today a written objection by Mr. Littlefield as public defender of Los Angeles County and as counsel for Mr. Bianchi to the standing of Mr. Filibosian to be the party to make such a motion or such request to the court. And of course, this is in the context of the fact that when the predecessor of Mr. Filibosian, namely Mr. Vandekamp, was district attorney, he sought to have this court dismiss the 10 murder charges, which motion this court denied. And when I denied it, I referred the matter to the Attorney General's office for its consideration whether or not to assume the prosecution. After 2 weeks approximately of study, the Attorney General's office did decide to assume the prosecution, and of course thereafter fully represented the people of the state of California in the prosecution of the murder counts. Of course, with some twist of irony, Mr. Vandekamp, having exited from the case as district attorney, inherited it when he inherited the mantle of the Attorney General's position, and it is, I suppose, this circumstance also that is deemed as some support by Mr. Littlefield for his proposition that it's Mr. Vandekamp who should be making the determination initially whether or not Mr. Bianchi has violated his plea bargain and should be sent to the state of Washington. So I'll hear first from you on your written objection, of course,
yes,
Mr. Littlefield.
The district attorney's motion to vacate the order is based upon a memorandum of understanding agreement between the parties, which was signed in 1979, the parties being the district attorney of Los Angeles County, the public defender of Los Angeles County, Dean Brett, B-R-E-T-T, of Whatcom County, a defense lawyer from Mr. Bianchi up there, and by Mr. McGecker, the district attorney up there. It was also agreed to and signed off by each one of the law enforcement agencies in this case, that is, the sheriff, the Los Angeles Police Department, and the Glendale Police Department. At no time was there any thought by anyone concerned that the district attorney would not be the prosecuting agency. But the whole agreement is for a determination of whether or not Mr. Bianchi was testifying truthfully and fully and giving information truthfully and fully, to be decided certainly not by anyone other than the prosecutor who was prosecuting the case. Now, by this court's order, the prosecutor became not the district attorney, but the Attorney General. They were the persons who were in court all during the trial to make the determination as to whether or not Mr. Bianchi complied with the terms of this agreement, not the district attorney of Los Angeles County. And certainly at this time, they would be the persons to make that determination so far as Mr. Bianchi's testimony at the trial. If Mr. Bianchi is dissatisfied with that determination, it would be the trial judge who would make the determination. But it would be improper, it's respectfully submitted, for this court to have the district attorney come in at this time when they did not prosecute the case. They were not there. Representatives of the district attorney's office were not there. The proper party is the prosecutor in the case, which would be the Attorney General.
All right, before I hear from Mr. Filibosian, we might as well tie up any loose ends. Let me inquire of you, Mr. Boren, whether, in fact, if it were to be the Attorney General's office that had the jurisdiction or responsibility over this matter, whether or not the Attorney General's office would be making the identical request of this court that Mr. Filibosian is about to make as reflected in the moving papers.
I've read the moving papers, Your Honor, and I've also consulted personally with Mr. Vandekamp, and our position is reflected in the district attorney's papers. That is our position also.
So if you would be moving, as is Mr. Filibosian, were it your responsibility, is that correct?
That is correct.
And secondly, you concur, if it is in fact Mr. Filibosian's responsibility, with the action that he is taking as reflected in his moving papers. Is that correct?